Hi everybody, it's Harvard lawyer Lee. Todd and Julie Chrisley are about to go to prison and they've exhausted their last chance to get it stayed. They're due to report to prison on January 17th. I'm going to make this as factual as I can so you can understand what they're accused of and why they are going to jail and don't have any way around it. But stick around to the end because I'm going to do something I don't usually do. I'm going to give you my opinion. Last summer, Todd and Julie Chrisley were convicted of bank fraud and tax evasion. This past November, Todd was sentenced to 12 years in federal prison and Julie was sentenced to 7 years. The court gave them some time over the holidays but ordered them to report to prison January 17th. In late December, the Chrisleys filed a motion for bond pending appeal. In other words, they told the court they're appealing their convictions and they want to stay out of prison on bond until the appeal is over. Now, I'm going to go just a little bit into the law so you can understand the arguments. Before the 1984 Bail Act, the presumption was that if you were convicted and you wanted bail pending your appeal, you got it. There were reasons you might not get it, but the presumption was that you got it. But after the 1984 Bail Act, most attorneys agree that the presumption flipped. It's the other way around now. So to get bail pending appeal, the Chrisleys have the burden of proof, and they have to show that they're not appealing just in order to get a delay. It's called for the purpose of delay. And that the appeal is going to raise a substantial question likely to result in one of four things. First, actually reversing the case. That way they don't have a conviction, they don't go to prison. Second, that the appellate court orders a new trial, and if they win, they don't go to prison. Third, that the appellate court takes away the prison sentence altogether, or its ruling does, so that they don't go to prison. And then fourth, that the appellate court reduces the prison sentence so that they go to prison for less time than it's going to take the appellate court to rule on the case. Now, notice those situations all have one thing in common. They look at whether the person might end up going to prison unnecessarily or for longer than necessary. What the bond on appeal is intended to address is situations where if the person wins the appeal, they may have already served more of a sentence than they ended up needing to serve because the court can't truly fix that. And oops, sorry, from the court doesn't fix that kind of problem. Now, when the Chrisleys asked for bond, they had two main arguments: that an IRS officer testified falsely and that the government used documents that it got as a result of an illegal search of a warehouse. I'm going to explain both briefly. First, the government put up an IRS officer as a witness, and that agent testified that the Chrisleys still owed money to the IRS for tax years 2014, 2015, and 2016. After the trial was over, that officer wrote the Chrisleys' accountant and said, oops, I see that they did actually pay the taxes for those years. Now, I did an earlier video on this after the Chrisleys filed their motion, and at the time I said I thought that was an unusually strong ground for appeal. And I said I'd do a video on the government's response. But the court ruled so fast after the government responded that I never really had a chance to do that. So I'll do it really quickly here. The government says the IRS officer who testified that the Chrisleys did not pay taxes in those years had actually gone into the IRS database and queried it. And the database showed no payments. The reason was that the taxes were paid in the name of one spouse, and then the returns were filed under the name of the other. So the mismatch meant the amounts had not yet been credited and matched to the return for the Chrisleys. But the government said the IRS officer had absolutely no way of knowing that. She testified truthfully as she knew it, and the government lawyers had every right to assume she was telling the truth because she thought she was. Plus, the Chrisleys had not one, but two witnesses who told the jury that the Chrisleys had paid the taxes. And the Chrisleys could have presented more evidence had they wanted to, like canceled checks, for example. Besides, it's not like the Chrisleys were on trial for not paying taxes in 2014, 15, and 16. So the government says this evidence was just sort of extra. Besides, the Chrisleys were years late paying these taxes anyway. In other words, the government's argument was, this really is no big deal. The government is right that the Chrisleys had other avenues, but I don't think this was a small event. An official of the government testified to something that admittedly was false, and that's not minor. And it would give the jury reason to believe the Chrisleys were lying about having paid their taxes, even in those years, that they were just deadbeats who didn't pay taxes. The Chrisleys had a second argument when they asked for a new trial, and also when they asked for the bond on appeal. Early on in its investigation, the government searched a warehouse, and the court ruled that search was illegal. There's a legal doctrine called the fruit of the poisonous tree, and the idea is that once a search is ruled illegal, the government can't use what it found in the search or anything that came directly as a result. If the government figures out ways to get the same information from other sources, that's fine, but it can't use the illegal search. The illegal search is the poisonous tree, and the things that the government finds as a result are the fruit of the poisonous tree, and they can't be used. The Chrisleys filed a motion to keep out some evidence they say was the fruit of the poisonous tree because it came from that illegal warehouse search. But they filed their motion 10 days after the court deadline. The Chrisleys say that's because they understood the government would not be using the evidence because the court ruled the search illegal. They say they filed as soon as they realized the government, in fact, did intend to use evidence from the search. The government's response was, first, you filed your motion too late. We've been using this evidence since the indictment, so it's not like it was a surprise to you that we intended to use this evidence. Now, note that neither of the two grounds that the Chrisleys are arguing is based on the idea that the Chrisleys are innocent. But under the American court system, these are valid arguments, and both of them reasonably serious, in my view. The Chrisleys also had a third, smaller argument that the court had miscalculated Julie Chrisley's sentence, and it should have been shorter. The Chrisleys argued that Julie should not be held responsible for the bank fraud loss, or at least not all of it, because she wasn't involved in all of it. If the whole amount of the bank fraud is included, that increases her sentence. The government's response was that she was responsible for the entirety of the bank fraud, plus it doesn't matter anyway, because, and you can go back to what I said at the beginning of the video, she had still been convicted of tax evasion, and the length of her sentence for just a tax evasion is longer than it's going to take an appellate court to rule on her appeal. The government also argued that the Chrisleys could not prove they are not a danger to the community. I have definite opinions on that, and I will be doing a whole video on it. When it came to the motion for a new trial, the judge didn't have much to say. She denied it with what's called a minute order. I can't say for sure why it's called that, but I've always figured it's because it takes 1 minute to write or 1 minute to read. The judge doesn't write out the reasons, just that she considered it and decided no. So there was not a written opinion with detailed reasoning. Now, the judge did the same thing with the motion for bond. That was just a no. At this point, there is nothing now standing in between the Chrisleys and their prison report date on the 17th. And now for my opinion, which I told you I'd give. When I started covering this story, I had never heard of the Chrisleys. I was just struck that the main characters in a supposedly wholesome reality TV show had been convicted. And I figured people would want to understand more about why. But once I posted on it, YouTube figured I was interested, and their show just kept popping up in my feed. And I have to tell you, I think the Chrisleys are absolutely hilarious. I think it's a shame that they will not be able to keep doing their show. I understand that what they were accused of and have now been convicted of is very serious. I just hate that it gets in the way of them using their talents and gifts to make the world a little more tolerable, to add a little humor to the world. Given that a jury found that the Chrisleys broke the law, the rule is they go to jail. But the losses from that ripple a long way out, far beyond just the Chrisley family itself. I did an interview too, actually, with Justin Paperny, which I'll link at the end of this video. He's an ex-con with a consulting business and a YouTube channel called White Collar Advice. He helps white-collar criminals prepare for the transition to jail. And the interviews he gave me were amazing. You've really got to hear what he said. And I'm putting some short clips out over the next few days on my channel in case you don't have time to listen to the long version. But the long versions are great, and I highly recommend them. Justin told me in the interview that he definitely has hope that the Chrisleys can find ways to pick up their careers when they get out. I don't know about that. Todd's the linchpin of the whole show. He carries it. When he gets out, he'll be 61 or so, and that assumes he serves about 85% of his sentence. Nanny Faye, who is arguably even funnier than Todd, will be 89. The Chrisley kids will have built new lives. Chase and Savannah will have spent 10 years on their own careers. Grayson will have gone to college and graduated, and Chloe will be 20 years old. But I will say personally, I hope Todd and Julie Chrisley make it their goal to keep going, because I think the world will be a better place if they do. And I, for one, want some more Chrisley Knows Best content. Be sure to like and subscribe, and I'll see you in the next video.